We will certainly call a second meeting this afternoon for whatever we don't get to this morning. So in light of that, we're going to go ahead and we'll skip around because we have some guests here from the House and some of our executive committees folks. And I don't think Senator Simmons is here yet. So we'll skip down to, let's go to House Bill 529, about halfway down the list. We've got Commissioner of Public Safety Tyndall with us. Commissioner, if you want to come and have a seat at one of the tables here and speak into the microphone, because some of our folks watching online, it doesn't help much in here to pick up the voice, but it does apparently help the people watching online to hear what we're saying. So we'll call up House Bill 529 and ask Commissioner Tyndall to kind of go over briefly what the strike all does.
Okay, thank you, Mr. Chairman. House Bill 529 was requested by the Department of Public Safety for some clerical language cleanup and other provisions. The original version of the bill allowed for, in section 1, a $10,000 death benefit that would be paid to any first responder, regardless of if it was a line of duty death. The language in the proposed committee sub at line 59 increases the in line of duty death benefit to 110,000 from 100,000. So that's the change there. It does take out the $10,000 death benefit for any first responder that dies, regardless of the in line of duty function of that. And that's at line 59. And then if you go to the next change comes at line 235 and 236. This is dealing with the records information on the insurance verification and liability coverage form. It makes it clear that it's exempt from a public records request, that information is for law enforcement and can be provided to insurance companies if they want to purchase it, but they can't circumvent that by making a public records request, because that's generally information that wouldn't be provided anyway.
How much does that usually cost if an insurance company wants to purchase that information?
It varies. It depends on how much and you know what they're looking for. If they're looking for a specific region or a specific type of accident. And so I can get those numbers for you.
It's like a per page, like I know some of our clerk's offices, it's a per page copy fee, but
typically we enter into contracts with these insurance companies and work with them on it, on providing it, so they'll know, I guess, what they charge per driver as far as history and things like that.
So this is not intended to deny anyone that needs this information getting it. You're simply saying that right now they're not wanting to pay for it, and they're circumventing that copying fee or the retrieval fee by calling it a public information.
That's right. And it's just a small number of the companies that I think are doing it. So our IT department requested that we clarify this language, that information would not be available through public records, but it could be purchased through the agency.
Okay, well, that's just a question I had. Thanks.
All right. And then moving forward to section 5, lines 310 through 316. The Criminal Information Center has been working to secure grants for live scan equipment. This is a federal grant, but the federal grant requires that if anybody receives this live scan equipment, that they have to use it. And so this just puts into law that if you receive a live scan equipment from our agency, you have to use it or you have to return it.
What does it do?
The live scan equipment is used for fingerprinting, and it scans their fingerprints in live time. A little bit better than the old fashioned roll your finger on the ink pad. So, and so that has to do with the federal grant and that part of it. Section 6, if y'all remember 20 years ago, kiosks were the thing. They've become real popular. There was legislation put in place that said that any local county that wanted a kiosk machine could request one, and we would have to put one at the courthouse. Times have changed, and kiosks are, I guess you could say, no longer in style. Plus, they cost about $50,000, and we don't know that they conform with the requirements of Real ID. What we're proposing here is that we use a broader term and just that we have a computer placed at every courthouse that requested. This is part of our vision of expanding the digital footprint of driver services and minimizing some of our physical footprint. And with this, what we would do is have a computer set up, public access for those that don't have access to the internet. That can't renew online because they might not have a computer at home, could come to their county courthouse. Get online, renew their license, get any other information they want, and even have access to a virtual examiner to answer any questions. But it would remove the kiosk. And so, and just so you know, those kiosks cost about $50,000 a piece compared to, we could program a computer for less than $10,000 to do the same functions. And then the last thing in section 8, we removed the repealer on the insurance verification system. That was a system that was set up several years ago, and that has worked out really well over the past years. It's helped raise money for trooper school, helped raise money for burn and trauma care in the state. It has also been good for law enforcement to verify insurance on the side of the road. So it's a system that we've set up, and we've asked that the repealer be removed for the insurance verification system, and that's line 888, section 8.
All right, great explanation. Questions for Commissioner Tindall? Senator Sparks?
Thank you, Mr. Chairman. Commissioner, on the new fingerprint system, the live scan, so that uploads immediately into APHIS upon taking that fingerprint at a police station. Is that the, I guess, intent of the system?
I think, and I'm not 100% sure of the intent of the system, if it's for it to be immediate, or if it's for to take advantage of the technology and have the lasting fingerprint in a digital format versus the ink ones. That sometimes you take that ink fingerprint, then it doesn't comply with the APHIS when you do submit the ink print. And so, like, anytime now that you go and if you want to get a suppressor or something like that from a firearms dealer, most of them now have a digital live scan fingerprint equipment that they use, and it immediately uploads to the federal system and lets you know if there's any issues or if it'll be accepted by the federal government on that APHIS program.
But this is also if someone is arrested, not, I understand purchasing a gun, maybe it's convenient for someone to have their fingerprint said, okay, yeah, he's got a clean record, he can buy that gun.
Right.
But for someone who's arrested and now has the digital fingerprint, if they receive a duly issued court order for expungement, will it also be removed out of the system like it is currently?
I would assume it, but I don't know that. So I can try to verify it.
Thank you.
Okay, Senator Suber?
Thank you, Mr. Chairman. Mr. Commissioner, I want to go back to section 6, lines 430 through 439. And explain again exactly what the purpose of this is. This isn't like a driver's license. Get a driver's license. It looks like there's having access to the Bureau website.
No, and it would be, they would have access not to the internal data, not to our operating system that like a driver service clerk would have. This would just be a portal directly to the driver services website. And one of the complaints that we got in trying to expand our online functions and renewals and things of that nature is that some folks don't have internet at home. Some folks can't afford computers. They don't have access to that. And then the driver service station is 30 miles away, 40 miles away. This way they can go to their county courthouse, have access to a public computer where they can go directly to the driver services website. And if they had any questions, then we would pop up a virtual examiner to talk to them and work them through any issues that they were having.
So this would allow them to renew their driver's license.
It would allow them to renew, just like they could online now, it allows them to renew it at the courthouse online.
Because I'm one of those counties that hasn't had a place for somebody to get their driver's license. That's been a big struggle because they have a lot of elderly people in the community and they can't just run to officers for them to do all the basically. Is there anything we can do to maybe implement facilities for have an actual person to talk to renew their driver's license? I mean, I know it's a cost deal, but
Yeah, I mean, that, and so it comes down to the cost. And if we want to do that and put one in each county seat, I mean, that's 81 counties and we need to have at least, even on the smaller ones, 2 to 3 people working there daily.
Well, we used to have, when they come by, at least once a month. Maybe a rotating.
And really, the goal of this is to have these terminals where we could set up and do the virtual examiners with them instead of it necessarily being in person. And then if they want to renew their license, we can mail it to them and handle all those functions versus having to set up in person in every county in the state. And the reality is it's hard enough with the 32 driver service stations we have to keep the lines from growing there. If we start taking folks out of those stations and putting them on the road, then we're going to get back to where we have lines. And this is something we're going to try to do to meet those demands so that that elderly couple that can't drive to the nearest driver service station could at least sit down in their county courthouse and have somebody help them through the process of renewing their driver's license. Thank you.
And then these are mailed, so I mean, there's not like a printer attached to these that spit those out.
There's not, we're actually one of, I think, 3 states that don't do central mailing for their driver's license. So most states, even at their main driver service stations, you don't get your license that day. It's mailed out. So the advantage to that is it does create better security. And it centralizes your print stock for your cards instead of them going out all over the state. And so you have a central mail where it goes directly to the individuals that have gotten their license.
Okay, Senator Thomas.
We are. It'll be tied into our goal is to have virtual examiners that can pop up and work with people through any issues that they have. So we'll have the capability of knowing if a computer's down or not. And if it's down, then we can send somebody to go work on it or try to get it fixed. But it wouldn't be the sheriff, it wouldn't be the clerk, anybody, it'd be our responsibility.
In some way.
Thank you. And that brought up a question. The real ID, is that still a ways off? Or I know it kept getting pushed back for a while.
It keeps getting pushed back. I think the latest pushback has taken us into 2024, or maybe the end of this year. I think it's 2024 now. So it keeps getting pushed back. One of the problems with the kiosk too, that prints the ID and drops it, is part of Real ID. That's not compliant with Real ID, just to drop a driver's license in the machine, give it to them.
So are these ones that are being printed out and mailed, are these real ID compliant?
Yes, they would.
Okay.
They would be. Now, the first time somebody gets a Real ID, they're still going to have to bring certain forms of identification, social security card and their birth certificate. But after that, they won't have to bring those anymore. So a lot of folks are already Real ID compliant. They've been going through that process in Mississippi for 6 years. And so most of our folks are getting to the point where they're Real ID compliant.
So are these things able to scan in those documents from the courthouse, or do you have to physically bring those into the driver's license?
To get Real ID compliant, you would have to physically come to a driver service station and bring that documentation.
Gotcha. Okay. Other questions, committee members? All right, for a motion? Strike all. Yes, Title 62 pass, strike all. In favor, say aye. Aye. Any opposed, nay? The ayes have it. Thank you, Commissioner Tindall. We appreciate you very much.
I'll get the answers to those questions.
Okay, thank you. All right, let's go up to the one right before it, House Bill 405. We have, I think, Mr. Charles Wood from the Audit Department. Again, this is one you've seen. We've already had a Senate companion bill to this, but I met with Chairman Bain last week, and we tried to limit the number of bills that were being passed in both chambers. So this is one that we agreed to take up with the House version. They're taking up some of our Senate versions of other bills. So this is a redo of something you've already heard, but if Mr. Woods, if you'll just refresh us as to what this does.
Yeah, so this bill, like the chairman said, is substantively the same as SB 2122 that passed on 25 January of this committee. And we're seeing increasingly complex cases in our office. And at times that involves robbery of a public official. And that often happens early or can even initiate a scheme. So We don't want to have our investigators, more importantly, our state and local prosecutors at a disadvantage when we're working with federal partners. So this would move the statute of limitations, robbery of a public official from the general statute in line with the federal time, which is 5 years.
And
That's what this bill
the
does.
general one is 2 years, correct?
Yes, sir.
So it would essentially bump it up
2 years
from
to
2 to
years.
5 statute of limitations to bring these cases.
Correct.
All right. Questions for Mr. Wood? Anybody? And Senator England? Motion is title to pass. All in favor, say aye. Any opposed, nay? The ayes have it. Thank you for being here with us this morning. We're gonna jump over to House Bill number 995. And we have Representative McLean with us from down the hall. Our friend at the house, if she'll sit there, this is a bill that she has authored and championed the past few years, and we're honored to have her with us this morning. If you will tell us a little bit about what 995 does, Representative.
Yes, thank you so much for having me. House Bill 995 revises the definition of rape. Currently, the definition of rape is to forcibly ravish a female of previously chaste character. That's in Mississippi Code Section 97-3-71. If you'll look on page 7, you will see what has replaced that archaic definition. And starting on line 152, this definition coincides with the definition of sexual assault and sexual battery that we currently have in our statutes. Also, this bill will repeal the spousal rape defense, which most states have repealed that statute years ago. We do have domestic violence in our state, and it's important that we remove this blanket immunity and repeal the spousal exception.
And for those that don't practice in this area of law and maybe watching online, tell us what that exception currently allows for.
Well, it allows for, it is a threshold defense for the spouse of a victim. So if a victim is raped, say by her husband, initially there is a threshold defense simply based on the fact that they are married. Of course, that could be overturned by evidence, say she was beaten up or something to that effect. So, but right off the bat, there's a defense to that. And that's something that we need to have repealed.
Thank you.
Be happy to take any questions.
All right, Senator Sparks.
Thank you, Mr. Chairman. In section 5, the redefinition, which I'm fine with, because I think the old definition was pretty narrowly tailored. And this new definition, would that not make the marriage exception, and it's not truly an exception, as you stated, it is actually a different category, because you do have people who are in a marital relationship. But since 97-399 already addresses that the legal spouse could be charged with sexual battery if they engaged in forcible sexual penetration without consent of the alleged victim, wouldn't the change of your definition in 97-371 adding penetration not clear that up?
Well, in 97-3-71, are you referring to whether or not his or her spouse?
No, I'm just saying you've redefined the act of rape. In other words, it's brought
Right.
the categories, which I'm fine with. I understand that. But the defense of marriage, if you will, which is way Westlaw listed in 97-399, already says, because technically sexual battery is what you had to charge unless you had the specific act of rape under the prior narrow definition of rape in Mississippi. Is that correct? Okay,
Yes.
so since sexual battery is actually covered, if the legal spouse engaged in forcible sexual penetration without the consent of the alleged victim, wouldn't your new definition actually make it more accurate that a removal of quote unquote, the defense of marriage is not actually accurate, because prior you had a very narrow definition that potentially someone could raise 97,399 as a defense. In other words, I think you've helped yourself by changing the definition in 97,371 without addressing the 97,399 defense.
All right.
No, I didn't know. if you had
Section
considered
2, under section 2, we're repealing 97-3-99. It's totally repealed on the first page
that.
there.
I understand. That's what I'm saying. But if you harmonize your new definition in section 5, it actually makes section 2 more applicable, because it still allows for sexual battery in that situation. I mean, I think when you change the definition and then 97,399 would actually capture your new definition, then it maybe keeps you from having the need of striking section 2.
Well, I still believe that battery against a spouse, no matter, what the circumstances, without consent that's our goal here.
But it's already illegal under 97,399, and that's what you're striking. The final part of 97,399, as the law reads currently, is that the legal spouse of the alleged victim may be found guilty of sexual battery.
Right.
So already they can be found guilty of sexual battery, but not rape, except under the, I guess, very limited definition. But because you've broadened the definition of rape, it actually encompasses the remainder of that sentence.
But sir, our rape definition was the forcibly ravishing a female of previously chaste character. That was our rape
That's
definition
what I'm saying. I don't
previously.
object to that. Your new definition of that is fine. That's great. But I don't think striking 2 accomplishes that, because you've actually broadened the definition to the extent that they could not have protection under this for that act, is, I guess, my question.
Okay, Senator Hill.
I guess in response to Senator Sparks's question, I guess my question would be, why would you want to leave a spousal defense for rape on the books, period, in section 2? So maybe I'm answering for Senator McLean, but I think I kind of understand where he's going. Is he wants this, sounds like he wants this left in the code instead of removed in section 2. And so my answer to that would be, why would you want to leave spousal defense of rape in the code, period?
Senator Sparks.
Well, the first part of that answer would be because obviously there are a lot of difficult relationships in this state. And while no one here would support the forcible or the rape or the battery of any individual, of a spouse or non-spouse, laws are weaponized in chancery proceedings. There are things that are not the intent of legislation that are manipulated. Now, in my question here, this is not a problem with the redefinition. My question is I think a legal one, is that the only defense that was allowed under 97-399 appears to be if someone was addressing sexual battery based on language that now more properly defines rape. So, this bill or this particular statute is not a bar to prosecution. It is just simply that we have broadened the definition, as we most likely should, but we've stricken something that was already in the law that was pretty clear that forcible sexual penetration without consent of a legal spouse was prohibited.
Okay, other questions for the author of the bill? Anybody else? All right, for a motion, Senator Hill. All right. You're right. All in favor, say aye. Any opposed, nay? The ayes have it. Thank you so much, Representative. We appreciate you being here this morning.
Appreciate you having me.
Absolutely. All right. Senator Hill, we'll go to you next. House Bill 795. Bearing in mind, this is strike all, but Senator Hill has been filing this bill for a couple of years. And so the strike all represents her language to a bill that was similar from the House. So Senator Hill, you're recognized to explain your strike all. Thanks.
Okay, what my bill does is revises the penalty for shoplifting based on cumulative effective amount of the merchandise. And it begins on pages. Currently, if you get over $1,000, it's a felony. So what this bill does typically says within 5 years, if you get a second shoplifting conviction and the merchandise for both crimes is aggregated less equal to 1,000, it's still a misdemeanor. So if it doesn't go over $1,000, second in 5 years. And 73 through 79, if it's your second offense in 5 years, your total goes above $1,000, that would trigger the felony. Whereas prior to having somebody for each shoplifting, 5 years.
When you say the cumulative total of the first and the second crime, are you talking about, I'm just trying to get it straight in my head. If you go to Target and you lift 3 items and those items don't surpass the threshold, but you add the 3 items that you have shoplifted up to get the cumulative total, is that what you're talking about?
That would be over 1,000.
So you're not talking about individual items on one shopping spree necessarily. You're talking about the cumulative total of multiple shoplifts. Okay, I just wanted to make sure. Okay.
Basically, it's for repeat shopping. Because our small businesses, that's the number one complaint we get from our small businesses is how much they're shopping. And by the same, so that, you know, that's what they tell me. I mean, so walk up and down Main Street and they tell me the same thing for shopping.
And they know how much the threshold is, so they make sure they keep it under a certain amount. Okay. Senator Barnett.
I have a question.
Sure.
So if I'm convicted of shoplifting the first time and go back and it happens again, so now you're gonna charge me with the first one and the second one. But if I'm already convicted of the first one, how wouldn't that be like double jeopardy, punishing me twice for the same thing that I've already been punished for the first time?
No, because you have not gotten a felony.
But it's still the same charge, whether it's a felony or not, you still charging me with that same.
Well, you're gonna get charged with shoplifting regardless the second time if you shoplift. This is just adding your totals up.
All right, Senator Sparks.
I'm gonna have to agree with Council Barnett, that if I go in and plead to a misdemeanor in a court and later they want to charge me with a DUI, let's say in a misdemeanor court, and later they want to raise that to a felony. If I've already pled, you can't replead that charge. In this situation, I don't know that legally, and I don't know would be my statement, but I would have great concern that trying to add an amount from a prior conviction, which may have been 3 years ago, and you've already made restitution on the first offense and you've had it expunged, you're not going to be able to add it to it. But I do think also we have statute of limitations in misdemeanor court typically of 2 years to prosecute crime. So, you know, while I understand the premise, because we actually went from 3 offenses in 7 years, several years ago, a third offense, if you stole a pack of bubble gum, it would be a felony. there was no economic threshold. Then we came back and I think put the $1,000, it was 500 at one point, we raised it up, but I do have concern if it's proper and legal to go back to a prior conviction and add it to a current charge, because if you take one element of a prior charge that has already been resolved, you're then putting me in double jeopardy of that, especially at the felony level. It's a legal concern.
Let me ask you this, Senator Sparks. So in light of that question, if you simply changed and said for a second offense, the penalty will be X, and don't worry about the amounts of money being, or the value being stolen, would that fix your problem?
I mean, I think that would legally be correct. Now, then it becomes a principal issue of, are we going to give somebody a felony on the second offense, shoplifting? And then that's kind of a broader question.
Gotcha. All right. Just trying to keep the legal arguments here straight. All right, Senator Hill, for your response.
So that would be my amendment. Council drafted this bill. I don't have a JD behind my name. I don't try these cases in court. I asked for a bill that would work, and you lawyers are telling me that it won't work. So my amendment would be a second offense in 5 years is a felony.
You've heard the amendments. Any questions on the amendment? Senator Hill. All right. Yep, Senator Barnett.
Yes, sir. If we're talking about offenses here, then, you know, we typically want to throw away the key and melt it, burn it, or whatever after somebody has done something for 3 times when we're talking about. So why are we trying to make something that's less than that only 2 times? And basically if we're gonna, I can agree with the amendment if it's more in line with what we do now as for the third offense. If it wasn't happened out in the third offense, people go in jail for a lifetime. So why should we let this mirror that? And I can agree if it's your third offense, then it will become a felony.
All right, Senator Hill, you're recognized.
What we would do on the amendment is we would leave the penalties the same on lines 74 through 79. Or basically the penalties are not more than $1,000 or imprisonment of, hang on, hold on. Sorry, on lines 58 through 62, we'd leave the penalties. We would just skip that one and leave the penalties the same as they were on lines 73 through 79 and make the second offense a felony. And then the third offense is also a felony, but it has a greater penalty. So we wouldn't change that on lines 80 through 85.
Okay, so if you will restate your amendment, just so that we're all clear as to what we're.
My amendment would make a second offense within 5 years a felony. Keep the penalties the same as they are on lines 59 through 60. 73 through 79.
So you're just basically striking
the amount, cumulative amount. I'm
You're
just striking
doing a
the
first, second, and third
Yes.
offense. Okay. I understand now. Sorry about that. I was confused. All right. Any questions, Senator? Yes, you're recognized.
Yes.
We had multiple hands going up. McCon, you're recognized.
There are more. You know, I have great concerns about where we're headed with this because our statute itself is pretty good as it is. Upon a third or subsequent shoplifting conviction with a value it's 500 to 1,000, you're already at a felony. Prior to that, as a former judge, often we were in a better position to keep people incarcerated if they were egregious in their crime. But in this situation, you've got up to 6 months on your second offense. 6 months in jail is probably more they're going to get than they're going to get as a felony in most courts, because by the time they get processed, they're probably coming back out and going back on probation. I find and disagree, and maybe some of the other judges, former judges in there can agree or disagree with this, but I found, and as being judge, that
that we had a junior college there. We had a little bit of trouble with that. But usually whenever you spent 24, 48, a week in jail, and mama had to answer for that, then it changed the whole tone. I also know that in Flowood, it used to be mandatory 3 days in jail, didn't care who you were. That's how they treated it. I find that you have more control and more access to working on things in the situation of a misdemeanor offense. I am concerned about going to the level we're doing where you say, you know, two $5 toys, the misdemeanor, it would have been 2 misdemeanors now or you've got a felony on the second one. So I think we've got it. I don't have an objection there, Senator, but I do have some concern.
If you look at, can I respond?
Yeah.
If you look at current law on line 63 through 65, the actual misdemeanor offense is for a term not to exceed 6 months. So that's already there. That's already there. So the felony only says not to exceed 2 years, but there's no minimum. The judge doesn't have to sentence anything if they don't want to.
I understand there's not a minimum. I understand how that works. I also understand that a third offense felony currently under statute is up to 3 years. So you've even cut it back on yours. So if we're trying to be stronger, we're going the wrong way.
I'm not changing a third offense.
Third offense, a felony would be up to 3 years.
Exactly. And
your
a
current
second
statute.
offense is not to exceed 2 years. So I'm not overshooting the third, the time on the third. The second one is up to 2 years. The third one's up to 3 years. I'm not overshooting the third offense.
That's
So I'm graduating the penalties. I'm not overshooting the third offense, and it's already as a misdemeanor, you can serve up to 6 months on current law.
Senator Hickman.
Thank you, Mr. Chairman. I just have a technical question. I have not exhausted my energy to read through this entire bill because I'm inclined to vote against everything about this bill, but I just want to make sure that the amendment is doing what I think it's doing. So if an individual steals a can of soup, they're caught and convicted of that, do whatever sentence they get, and then 3 years later, they steal another can of soup, they now are going to be held under a felony rather than a misdemeanor or shoplifting that could equal somewhere between $2 and $3. Is that what the amendment does?
No, we're just taking the aggregated amount out. We're
Right.
leaving the $1,000. We're just taking the aggregated portion out.
But in practice, you're saying 2 misdemeanors, which could be any amount, now equal a felony. Is that correct?
No, that's not correct.
So what?
We're just taking the aggregated amount from the first charge. We're leaving the $1,000 in there. We're just taking the aggregated part out so that you can't add from the first offense.
But it's my understanding that we're saying now 2 misdemeanors, which you don't have to reach that $1,000 threshold. And if you're taking the aggregated amount out, we're not even looking at the 2 amounts. We're just saying 2 misdemeanors, from my understanding of the 2 misdemeanor offenses now equal a felony. Is that not what we're saying?
I'll have to defer to Senator Hill. It's her amendment, so it's not really written down before us. So I'll have to ask her to respond to that.
You're basically saying on the second offense, if it's $1,000, it's a felony.
All right, Senator.
Is that not all?
It's not. There's only talking about fines. So I think I know what Senator Hill is wanting.
Yeah.
Just make a second offense if your offense exceeded $1,000. Is that correct?
Yes,
Is that would be a felony?
yes,
Okay.
yes,
It doesn't say that in here, it's only about fines.
Right.
It's talking about fines.
right. Well, when you've got the $1,000 in here, but we're taking the aggregated portion out. We're just saying $1,000, more than $1,000. We're just taking the aggregated amount out. So if you get a second offense, that's $1,000 within 5 years, it's a felony.
That's gonna be grand larceny. Sorry.
And that's my point. It's already a felony. So we're not even, I mean, we are putting words into code. If that's what we're trying to do, that are not necessary.
Okay. Ethan, I think Mr. Sampson wanted to make it clarifying. Oh, you're good. Okay, sorry. All right, back to Senator Hill. Is her amendment, what would you?
My
like?
amendment is on a second offense, shoplifting within 5 years. If the amount is between $500 and $1,000, it is a felony. That's my amendment.
Okay. You've heard the amendment. All in favor, say aye.
I,
Any opposed, nay?
No.
Believe the noes have it. Do you want to ask for a show of hands?
yeah, I'd like a show of hands.
Okay. If you're in favor of the Hill Amendment, raise your hand. Or if you are opposed to the Hill Amendment, please raise your hand. All right, chair is no longer in doubt. I have it there. All right. So that amendment fails. We're back on the bill as it is currently before us.
I'd like to make another amendment.
All right,
Like
You're-
to add a reverse repealer to this bill so that we can take some time to work on this because our small businesses deserve more than what they're getting now as far as this shoplifting is concerned.
all right, Senator England.
Thank you, Mr. Chairman. Yeah, I just wanted to speak to the amendment just briefly if I could, and
Sure.
just say I was going to offer the same amendment. I respect what Senator Hill is trying to do here for small business owners in her community and other communities in Mississippi. And I hope we can pass this bill out of committee today on deadline day with a reverse repealer to allow us to continue to work. I think we've had good discussions on it, and there may be a good amendment that we can get in that we can all live with that serves the purpose Senator Hill is trying to make. So I support the amendment and just want to make that statement.
Senator Hickman.
Mr. Chair, I just have a question about something I think you said earlier. This bill, you said how many years has it been dropped?
Several.
And so we haven't got a bill that's workable up until this point, and we're gonna do it in the next couple of days.
No,
Next 2 weeks.
I have lots of faith in this committee. Yes. Senator Barnett.
Yes, Mr. Chairman, we've heard from one judge, and I'm sure we have several others. We took a vote on an amendment, and I asked that we table this meeting.
You're not recognized for that motion. We're on the amendment right now. So would you like to speak against the amendment?
I would like to speak against him.
You're recognized to speak against the amendment.
Can I close?
Yeah, you will be. Mhm. Go ahead.
We've heard from at least one, and we have other judges here. And individuals who have practiced it. It's not that we don't want to see something happen, but we just don't want to see the flaw of what we currently have to not be effective at intervening with in our court system. So I'm asking again is that we vote against the amendment. And also, Mr. Chairman, I would like to have another comment or after this vote before the Senator Hill's motion closed.
Well, the author of the amendment is the last one recognized to speak. So if you want to say something about it, you're certainly recognized now to say whatever you would like to say about the amendment.
Well, that's all I had to say on the amendment, but I
Okay.
would like to speak before.
Okay, sure. But she'll be recognized to close on her amendment as the
before
last
final
person to
passage.
speak. Yeah. Gotcha. I got you. All right. Did anyone else want to speak on the amendment before recognizing Senator Hill to speak on her amendment? If not, Senator Hill, you're recognized.
Thank you. This bill did pass the House in a different form, and they basically had 3 offenses within 30 days. Was a felony. So there are legislators that are talking to their members about shoplifting. Small businesses cannot absorb $999 every time they turn around of merchandise. We have got to do something to help these small businesses. Ever since we raised the threshold from $500 to $1,000, they have seen a lot more shoplifting. And that's what they tell me every time I walk up and down the streets in my town. So that's why I'm asking for this reverse repealer so that we can look at something that will work to further deter shoplifting. And you've seen in these big cities, they've got flash mobs coming in and breaking into stores. We've even seen that on the coast, because if they take a misdemeanor amount, nothing happens. So what we're saying is we want to put some threshold in there that will allow a second offense to be looked at more heavily. We want to do something for our small businesses. And, it's our responsibility to make sure that we have a business-friendly environment in our state for people. And it's not just small business, it's Walmart and everybody else that's seen this uptick in shoplifting. And they all say that it's been since we implemented House Bill 585. So I'm just asking to give us a chance to look at what we're doing with shoplifting to see if we can do something to further help these small businesses and deter shoplifting.
All right, you've heard the opinions on the amendment. All in favor of the amendment, please say aye.
Aye.
Any opposed, nay?
No.
Believe the ayes have it, unless y'all want to show them. Anybody? All right, let's go for it. All right, if you're in favor of the amendment, please raise your hand and keep it up so we can count them. Yeah, okay. All right, yeah, okay. If you're opposed, please raise your hand. The chair is no longer in doubt. All right, the amendment does pass. All right, Senator Barnett, you're recognized. I think you wanted to speak before final passage on the bill. Yes, you're recognized.
Thank you, Mr. Chairman. Again, it is not my intentions to not at all want to hurt. You understand, I'm a business. I do understand. You know, it is tough to see someone come with this. We all understand this. But I think that we should trust in a judicial system that we have in place in this state and in this country. I think that we should trust the laws that we have already on the books that makes it tough on some. I think at the end of the day, the decision that our judges render, them are good. I just think that, you know, again, that comes back to not the interpretation of the law, in my opinion, a lot of time, but how the judge sees. I just think that we have judges that have made some good decisions and done good things to help improve it. I'm not trying to actually table this so that it doesn't ever come back up, but I just think that we need to table this so that we can, and instead of a rush in the next 30 days that we have to try to scramble and put something together, piecemeal, something that we may or may not be okay with. It's not timely enough to do this. And I think that we should consult with our judges and our DAs and everyone else that's involved in this so that we can come back and put together a comprehensive bill that we can all agree on and in both chambers and not have a discussion that lasts over 2 or 3 minutes because it's something that we are failing at it because we're rushing to do things. We haven't included all of the bodies or all of the parties that should be talked to in the midst of the discussion while we're doing it. So that is why I'm asking that we table this until we can get something where everybody has a say in it and we can make sure that it is a definite good bill in the state of Mississippi, not have to come back next year or 2 years from now and have a continue to change. So that's my motion.
Well, you're not recognized for a motion, but you're recognized to speak against the bill, which you have done. Senator Suber, you're recognized to speak on the bill.
Thank you, Mr. Chairman. I think we're trying to overcomplicate this. You know, I think the law's good at what it is, but maybe on the third offense, the third conviction, misdemeanor could be a felony. So you don't have to have a dollar amount. I think you would give somebody stealing minor items, under $1,000. They have 2 opportunities in the third offense, then they could be charged with a felony. We have that, DUI is the same way. You have first, and the second, and then the third can be a felony. So I feel like we can maybe just go to, I'm looking at the code, section 6. It matches up, and it just says, a third or subsequent shoplifting conviction where the value is not less than 500 or 1,000 should be guilty of a felony. Well, if we could maybe just put something, a third or subsequent offense, no matter the value, could be a felony. And I think we'd eliminate a lot of this language. To me, it's kind of confusing. I mean, if you're sitting up there on a bench, as Senator Khan used to, and I know we have a few defense attorneys in here. But I think we're trying to overcomplicate something. We all kind of have the same idea that we want to stop, these flash mobs, these kids coming in stealing a lot of stuff. I think we could just go to a third offense and be a lot better.
Would you like to offer that as an amendment?
I mean, I would offer that as an amendment.
You're recognized for that amendment.
Upon a third or subsequent shoplifting conviction,
Yeah, but he's recognized to make an amendment if you'd like to.
I would keep everything the same except just change the third offense.
Restore the code section except for get rid of where the value of the shoplifted merchandise is not.
Yeah, just
Greater
a
than-
third or subsequent shoplifting conviction,
The defendant shall be guilty of a felony and fined not more than, and restore the language just as it is. As a strike all.
yes,
Do you want to reverse?
we probably need one.
Yeah,
Reverse repealer.
you're leaving the first repealer in it. Yeah. Okay. You've heard the amendments to the bill by Senator Suber. Any questions on the amendment to the bill? Yeah, it has the reverse repealer still in it. Yeah. Sure, you're welcome.
The current will lawfully, right?
It looks like on line 10 and 11, it says purposely, knowingly, and recklessly. The code section now is willfully and unlawfully.
Okay, any questions on Senator Suber's amendment? If not, all in favor say aye. Any opposed, nay? The ayes have it. All right, Senator Hill, you recognized for a motion.
Out of sufficient do pass, strike all.
You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay?
No.
All right, let's have a show of hands. All in favor, raise your hand. Be counted. All right, chair is no longer in doubt. All right, let's get all opposed, please raise it loud and proud. Okay, duly noted. The bill is passed. Before we go, I do want just very briefly, like 5 minutes. We're not going to call the bill up because we're not going to have time to get all the way through it, and I apologize for that. But we do have some guests here. I want to recognize, introduce to the committee. It's House Bill 1371. We have Pastor Brad Eubank from the First Baptist Church of Petal, Mississippi. Dr. Lloyd, is it Sweet or Sweat? I'm sorry, Sweat, who's currently the president of the Mississippi Baptist Convention and pastoring currently at Meadowood Baptist Church in Amory, Mississippi. Miss Marie Till, Dr. Parker's executive assistant, and I think Brother Eubanks' mom maybe was here too. So, Brother Eubanks, if you'll just stand quickly, literally like 5 minutes, because we've got to go in session at 10, and just kind of introduce what the bill does in the strike all amendment and why you think it's needed. And then we're going to come back later this afternoon to take the bill up. I know, I'm sorry, that's my bad.
This bill, just in a summary, is designed to address the issue that unfortunately we have to address. What we call sexual abuse of adults, and by a minister, pastor, or a social worker, doctor, nurse in the role to use their authority, their power, and their influence to convince someone to enter into a sexual relationship of some kind. It is designed to talk about the idea that a person, when they use that authority, they lose their ability to consent to that action because of the person's power and authority position. This is a bill that has been encouraged. It's passed in 14 states, something similar to this. In 14 states, I'm looking at 15 states to do that. Or to answer any questions.
So I have a couple. So we're talking about adults. We're not talking about minors. So there are already laws on the books regarding these types of situations where minors involved. So you are talking about adults in this particular bill, correct?
That is correct. And we're confined to what we call a counsel-type relationship. So there's been a relationship that's been established. One of the questions we've got is the idea that not to use it, right, it's not a one-night stand. This is something where a relationship, patient, and client established. And a pastor, one of those, we're speaking about happening. That relationship is established, and then they use that relationship to gain access to the patient because of their emotional state, because of the condition that they're in mentally. They use that and twist that and gain access.
So what you're essentially arguing, and I'm playing devil's advocate here, because we've had conversations over the weekend about all this. But you're talking about essentially two adults that are agreeing to have sex with each other. One of them happens to be a employee of a church, be it a pastor, associate pastor, a church counselor, something along that lines. Some may argue, while we may disagree with the activity, certainly is not good or ethical even. Should that be a crime between two consenting adults? And your response to that is what?
So the idea that a person cannot offer consent because they are being emotionally, that person that it goes over them would have established a way to have twisted and used their position of authority. We talk about it when there's a social worker, counselor, pastor, who wields that in such a way that person is unable to really provide it. And the law writes here that they've established an emotional dependency. There's been an ongoing relationship. So this is not an adult that would have a difficult time consenting because of how it's been used and using that counseling, those methods that we use. And I can give you countless examples of where this has happened. And of course, there's not the case, but it's happened. It's consenting adults in the sense that that person, if it's not consent, then it's rape, right? It's on a bill, but consent, that it's consent, that person did consent, didn't say no, but they were in a position, because of their condition that they were in, they could not get consent.
And the purpose behind it, from the proponent's perspective, would be you don't want these individuals. I mean, you can fire an individual that you think is engaging this type of behavior, but then they simply go on down the street to the next church or to the next counseling situation. So their abusive behavior continues. You want to be able to call it a crime and stop it where it's happening.
And that does happen. I talked to a church weeks ago, and I'm asking them to do police. Another church, the exact same thing. It's also another part of that.
All right. As I said, Senator Sparks, real quick.
Are there any other adult relationships of consent that are criminalized in the state that we're aware of? Because as an attorney, if I had a relationship with a client, I would breach several ethical duties as an attorney, and I could be disbarred, but I don't believe I could be charged with crime. That's a question I'd like to figure out before we come back to this. Is there any other consenting adult relationship in the state that is criminalized?
Senator Wiggins.
Just a quick snapshot of the penalty. You're asking for it to be a misdemeanor?
On the person.
Well, okay, so if we're trying, I consider what's being described here very serious. If you use your therapy to gain access for sexual relations, that's serious, and a misdemeanor is not going to stop that.
And in
So-
fairness to Brother Eubanks, I think his original bill has a much stiffer penalty. I think
Okay.
in conversation with the Lieutenant Governor's office, staff members, perhaps it was thought that may be a bit too harsh.
Well, okay, I will move forward, but this is equated to a position of trust in sexual battery, which you get no misdemeanor. In fact, you get 30 years or something. I think that's something we need to look at, Mr.
All right,
Chairman.
we're gonna motion to
Okay.
recess, subject to call of the chair. All in favor, say aye. Any opposed, nay? The ayes have it. Thank you all.